Can you hear me now? Yay! I'm so sorry. We are, this learning curve is pretty darn steep. So, back to the beginning, since I was talking and nobody could hear me. I had a couple questions about why we were on the same time as John and Lauren Matthias on Hidden True Crime. For those who've been here a while, you know that I started out appearing with John and Lauren and now decided to brave all this weird technology myself to come to you live. John and Lauren decided to go an hour early this week because they have a lengthy pre-recorded interview with Chad Daybell's sister-in-law, Heather Daybell. I'm sure it's going to be really interesting. It is pre-recorded, so you could drop into it after we're done here as well. But that was a decision that they made based on the fact that they had this lengthy interview that they wanted to share. So beyond my control at this point, I'm glad that y'all are here, and I appreciate you being patient with me while we figured out the technical stuff. So I appreciate you hanging in there with me. You know, the best laid plans. Michelle and I both tested out everything and had everything ready to go just before the show started, and then suddenly nobody can hear me. So I do have a couple of other things I wanted to say and to share today. And one of those is kind of an exciting new announcement. I'm going to be doing a Tuesday night show. And that Tuesday night show, unlike Friday night, won't just be devoted to the Daybell case. We'll be talking about other cases as well. Had a lot of questions about Delphi, about Murdoch, about the Piketon Massacre trial that's going on. So lots of folks have already put this out in my newsletter earlier this week, and lots of folks have already sent me questions. But please, the mods will put the email in the chat. It should also be in the show notes. So please send me questions if you have specific questions about cases other than Daybell that we can talk about on Tuesdays. So, and then today's Veterans Day. So for all of you who have served or have loved ones who have served, happy Veterans Day. Here's a picture of my favorite veteran, one of my two favorite veterans, my husband, Carl, and the other one is my dad. We lost my dad in 2017. There he is in all of his VFW finery. He actually lied about his age, used his brother's birth certificate to get in the Navy at 16. And it wasn't until he was nearly retired from the military that that one of our presidents offered amnesty to anyone who had lied about their age because it was a crime. And he was able to finally go back and correct the records and tell everybody that he was actually 2 years younger than all of his records said. So I miss him every day. Thank you so much, Kathleen, for your super chat. I appreciate that so much. I want to just remind everybody that if you, I always want to thank everybody for their generosity first. If you are kind enough to send us a super chat, all of those chats go to our moderators. So please keep that in mind and remember that otherwise they're here just volunteering out of the goodness of their hearts. And, you know, it's nice to be able to buy them a cup of coffee or a glass of wine. So I want to say thanks to everybody who's joining us tonight, and let's talk a little bit about this week's hearings. Specifically, we had a hearing on Wednesday, Wednesday afternoon. Wednesday morning, there was a scheduling conference that was scheduled, and the judge vacated it. So I'm assuming that that was a scheduling conference to set new trial dates, and that probably didn't happen because Lori is still, her case is still temporarily stayed, waiting for the outcome of her competency. So that morning hearing didn't happen, but there was a 4:00 hearing. That one was closed to the public. The judge issued, properly, I might add, issued an order saying that the court that it was going to be closed because it dealt with Lori's competency mental health issues that are specifically protected under Idaho law. So that hearing was held. From what it appeared, it was a hearing to review the report that had been offered by the Idaho Department of Health and Welfare and the evaluators that were assigned to evaluate her case. So we don't know what happened. I was a little surprised. Thank you very much, Darlene. Thank you from our mods. I was a little surprised that we didn't see an order before the end of the week, but the judge did have Chad's hearing on Thursday, so that may have bitten into his time that he had available to draft orders and do those sorts of things. I expect that we're going to see an order that commits Lori back to the Idaho Department of Health and Welfare for rehabilitation services. Now, I will say that I think it will be a much shorter time. The reason I say that is twofold. One, because there is a standing order for Lori to take medication during the pendency of the trial. And two, the evaluators have already had an opportunity to look at her, do the testing, evaluate her, and so I think they already really know what's going on with her. So I think her commitment this time is going to be much shorter. What we know about psychotropic drugs is that they can be somewhat unpredictable. So the most likely way that a person with what we think is her diagnosis, the rumors that have circulated, the most likely treatment for that is medication. So, but psychotropic drugs are pretty unpredictable. So we don't always know when a psychotropic drug might stop working, or whether they may need to adjust levels or try something different. So I suspect that she's going to be recommitted, but that her commitment this time will be much shorter than the 10 months from last time. Because if you recall, at the beginning, there's an evaluation phase, and then we know that there was a substantial period of time that she was refusing to take medication, and that it took a court order from the judge to order her to start taking that medication. So I suspect we're going to see a commitment, probably a much shorter period of time. The other hearing that we had was the hearing we had on Thursday, and that was Chad's motion to sever. You might recall that John Pryor submitted a 30-plus page motion. It was very well argued, very well set out, talking about the reason why the two cases should be severed. I didn't drive over to Rexburg this time for that hearing because I thought there was at least a good chance that a lot of it might happen behind closed doors. As it was, it didn't work out that way. But I did listen to the recording, and I do have some notes, so forgive me while if I'm reading notes to you, but I want to be sure that I have it accurate for those of you who didn't take the time to sit down and listen to the hour-plus hearing that went on. One of the things that John Pryor point that he made was to expand a little bit on what was in his motion by saying that that there's significant information in the case that will come out of the Arizona, that came out of the Arizona data dump. Significant information in the case that will need to be presented. And then there was a whole lengthy discussion about hearsay and whether or not that evidence is hearsay. He also talked about the Netflix series that came out that focused on Colby and made public a lot of the things that were in the Arizona FOIA dump. If you recall, we've talked about this before, but some folks may have not caught that one or may be new to the channel, I hope. Arizona and Idaho have very different exceptions to the Freedom of Information Act. Every state is free to adopt a federal act like that in a slightly different way. So in Arizona, they do not have an exception that says you don't have to release anything in a pending case, a case that's still pretrial. In Idaho, there is an exception for information pretrial. So Arizona released information under their FOIA statute and released a lot of information pretrial. Idaho, on the other hand, has been very tight-lipped about how information gets released. So what happened was quite a few different media outlets filed Freedom of Information Act requests with Arizona, and Arizona did this. Both Gilbert Police and Chandler Police, which are two suburban, little smaller suburbs outside of Phoenix, Arizona, and they're side by side. So Brandon Boudreaux's shooting was in Gilbert, and the city of Gilbert Police responded, but Charles Vallow's murder happened in Chandler, and it was the Chandler Police that responded. So both of those agencies released all of the information, some of it redacted, but a lot of information came from those two big data dumps. So John Pryor was talking about the fact that there was a lot of information that was released to the public and then used in that Netflix documentary that otherwise would not have been perhaps accessible to the public. But if it weren't for the fact that Arizona chose to release it. So there's two different issues going on. One is whether or not that information about the crimes in Arizona could be presented to a jury to prove that Lori and Alex, her brother, Alex Cox, committed crimes, and then they could infer that they were bad people, bad actors, and if they committed crimes in Arizona, it was likely that they committed crimes in Idaho as well. That is called 404B evidence, which is the rule of evidence that it falls in under. In general, it's a rule that restricts the prosecution from bringing in proof of prior bad acts to prove that the defendant did the current crime because they committed a similar crime someplace else. But we do have this issue of what is usually referred to as reverse 404B information. And that is information that the defense wants to bring in specifically for the ever popular Soddy defense. Soddy, S-O-D-D-I, stands for some other dude did it, which is a shorthand for defense lawyers. So bringing in introducing information that would suggest that someone else committed the crime, that Lori and Alex acted independently and Chad was simply a foolish rube bystander who was naive and taken advantage of by Lori and her evil brother. Good point, brown-eyed girl. We're live, and and be sure and let your friends know that we're up and running. And I know that there are people who are going to want to swap over to Lauren and John's broadcast. And I'm very fond of Heather Daybell. I've met her, and I think she has very important things to say. But on the other hand, it is a pre-recorded interview. So if you wanted to, you could pop over there and catch up. So the argument that John Pryor was making was that it's going to be very important for Chad to bring that information in, because he's going to be bringing it up to say somebody else committed the crime. On the other hand, Archibald and John Thomas are going to want to limit that information coming in because it would incriminate and prejudice Lori. So what is the likelihood of it being separate trials? It's a little hard to say in Idaho. If this were a federal case, I would say they're going to sever. It's just, they do it in almost every federal case. But remember that we are in small jurisdictions. And I think that although it shouldn't, I think it will impact the judge's considerations in thinking about how it is putting a terrible strain on little Fremont County to try one 10-week case in Boise. If they have to try 2 10-week cases in Boise, I think there's going to be that's a much greater hardship. So I think the judge is going to consider that, even though he probably shouldn't. He probably should be focusing on whether or not there could be prejudice to either of the defendants. Now, one of the points that Pryor makes is that it's not only about the guilt and innocence phase where Chad might be prejudiced, but it's also during the mitigation phase. And I think we're probably going to see some motions on this, but Pryor made the point that there is a gender bias in death penalty cases. And it's clear that there is. Juries are going to be less likely to find a woman to invoke the death penalty against a woman. And if it's a husband and a wife, historically what happens is the husband gets the death penalty and the wife doesn't for some reason. I think it's part of our gender bias. And so there is some research out there to support what it is that Pryor's saying. And I think we're going to see some motions about that, just like the motion we saw from Archibald about whether or not it's prejudicial to qualify a jury for the death penalty by saying to the jurors, This is a death penalty case. If you have some sort of religious or moral belief in not imposing the death penalty, you can't sit on the jury. So I think we're going to see more of those kind of motions, which are sort of generalized death penalty motions about gender bias, about death penalty qualification causing prejudice. We're going to see a lot more of that. If the defense uses information from Charles's death, can the prosecution bring in Chad's text messages to Lori about the insurance and the call to the funeral home? Sure. I think that the defense is going to be able to spin that as Chad was just trying to help her out. He was just, it was a really hard time. He didn't realize that there had been a murder. He was really just trying to help her out because he had experience in the funeral industry. He'd been a cemetery sexton. He knew the language. He knew what to ask. And so he was just trying to help her out. I think that the text messages about Lori being frustrated about the fact that that Charles had changed his life insurance are a little more damning, but I think the defense could paint that as she was frustrated because she had kids to raise and Charles had changed the beneficiary on his insurance to Kay. I think both of those things are small pieces of the puzzle. Certainly the prosecution can bring those in. Not sure how persuasive they'll be in the big picture. So what John Pryor said was their versions of the facts are going to be very different, and that because of that, they're entitled to sever the cases. Okay, Beth. Yeah, we were just talking about that. They do open the door to that case to an extent. Let's remember that case hasn't been tried yet, so it's still pre-trial. It would be easier to bring that information in if that case had already been adjudicated. But he did make that phone call to the funeral home. I think if you listen to the call, I mean, it's a little weird that he kind of uses a variation on his name so that he's not really giving his name. It's a little weird that he's talking about his uncle and, he's kind of distorting the facts. But I think that the defense would be able to spin that by saying he was just trying to help Lori out. She was under a lot of pressure. This horrible thing had happened. And he was just trying to be a supportive friend and more than friend, partner. Donna B., do I think that the judge could have one trial and two juries? That is a possibility, and that was certainly what was suggested by Lindsay Blake. One trial and two juries is difficult because it has to be very specifically choreographed. So it means playing it like a chess game, 3 moves ahead, and thinking, okay, if the next piece of information that comes in is this piece of information, and it really only applies to Lori and not to Chad, we need to get Chad's jury out of the courtroom. And that's a little tough sometimes. It's really a dance that the judge really has to make sure that the jury, that Chad's jury is not hearing things that would be prejudicial to Chad, and vice versa. Lori's jury isn't hearing things that Chad might bring in that might be prejudicial to her. What that means is, Sandavillo, could they have the trials run simultaneously to save on housing witnesses and experts? That would be tricky. I suppose they could do it. They would have to bring in another jury, and they would have to run 2 courtrooms in the Ada County Courthouse. That's going to be tough. I think it would also be difficult from the standpoint of court staff, law enforcement staff. I mean, to have 2 major international cases where there's so much media interest, I think that would be tough. I don't think it's impossible, but it, again, would take a lot of choreography. In addition, they would need to have prosecutors in both courtrooms, and that could be a big ask. It could be, I'm trying to think through that as we're talking. That would be difficult when you have basically 2 prosecutors and a couple of assistants. So it could be difficult because both of those prosecution offices are small. I mean, there's only one other attorney in Fremont County, and I think there's 2 in Madison County. So, and one of those attorneys in Madison County only does juvenile. So it would be a real challenge. Now, if they were to turn these cases over to the state AG and have the AG's office prosecute them, then yeah, I think they could do simultaneous hearings, trials. Flashback. Chad received over $400,000 insurance money for Tammy. Where did it go? If it was used to pay John Pryor, would he have to return it upon Chad's conviction for Tammy's murder? No, he would not. My understanding is that Lori and Chad had a great time and spent a lot of money while they were in Hawaii. My recollection is that when they returned from Hawaii, there was about $120,000 left. Now, there was a substantial period of time when they were paying both Mark Means and John Pryor. And it wasn't until Chad ran out of money that he signed his house over to John Pryor. We know maybe there's $100,000. That was being generous in value on that house. And I'm certain that that money's been eaten up and long gone. These kind of cases generate a lot of expenses, not even attorney fees, just expenses of hiring companies to do surveys when they were talking about change of venue, expenses having to do with having somebody who tests and retests and all of the forensic evidence. So yes, when they came back, there was about $120,000. Chad had about 80 to 100 worth of value in his house. So I would say there's probably about $200,000 that went toward attorney fees. There is no obligation to return that. So talking a little bit about basic contract law. When a person gets an insurance policy, they make a contract with the company that carries the policy. And if that company later discovers that they've been defrauded, they have several avenues that they can pursue recourse. They could go to the state law enforcement, whether it's the insurance commission referring it to the state AG, or hard. I don't know what that what that particular route is in Idaho. But the insurance company could go to law enforcement and say, this was fraud and we want these people prosecuted. In this case, it's not going to make one bit of difference because they've already got the death penalty hanging over their head. So it's not as if the insurance company is going to get a fraud conviction against them and get some sort of a judgment and make them pay it back. So the other recourse is to Michelle, go ahead and leave that question up and I'll answer it just as soon as I'm done. The other recourse is to go after them civilly and to sue them for a breach of the contract that they entered into with the third party. In this case, that would be the insurance company suing Chad. Well, there's not much point to that because he has nothing. He's what lawyers call judgment proof. I mean, you can get a judgment against him, but he's never going to get out of prison and he doesn't own anything. He's indigent. So I don't know that the insurance company has much recourse. John Pryor entered into a representation agreement with Chad, and that's a contract too. And Chad paid money for services to John Pryor. The insurance company can't come back and say, well, that was really our money. Chad stole it. Chad is actually the person who owes the money, not John Pryor. So under maybe normal circumstances, it's possible that the insurance company could come back against them. But as I say, there's no deep pocket. There's nowhere for them to go to get the money. So all it is paying attorneys to file suits and racking up more expense for the insurance company. And what the insurance attorney would say is, it's just good money after bad. You're already out $430,000. Do you want to rack up another $200,000 in expenses in the expense of bringing a lawsuit? So Lee here wants to talk about the CAST system. We talked about that last week. CAST stands for cellular. Can't pull it up right now. If the mods might look it up for me, that would be great. It's the FBI CAST system. It is essentially an algorithm for analyzing data. So the CAST system alone may be called into question. We talked last week about scientific evidence and when it's reliable and when it isn't. And what we know is that there have been recent cases where courts have thrown out the CAST data because they say that it doesn't meet the Daubert standard, which is the case that lays out what you have to prove in order to prove that a scientific method is reliable. So we don't know at this point whether this particular court will find the CAST information valid or not, but we know that it has come up in a motion that has now been sealed, and that there was a report provided from the prosecution to the defense about CAST and its reliability. So essentially what happened was the FBI said cell providers collect all of this data. They have all this data. They didn't collect it to figure out where the person who has one of their cell phones is located, but they have it, and it's all this raw data. Is there a better way to analyze that data? Is there a formula that we can come up with, a scheme for analyzing the data that will let us more accurately pinpoint where a particular cell phone is? Now remember, this is a passive cell phone. This is not a cell phone where somebody's standing there and making a phone call. That data has a very different analysis. But we're talking about this passive cell phone data where you just have the cell phone in your pocket and the communication is open with your carrier. So the FBI came up with this analysis scheme, this formula for how they would put all this data together, and using data that wasn't never really intended to be used to pinpoint someone's location, having to do with time data, they were able to come up with this formula and apply it to data. And they claim that it is accurate within a few feet. So they use that data to pinpoint some locations in Chad Daybell's backyard. If that were the only thing they used to pinpoint those locations, potentially a judge could say, I'm going to throw that out. Then the prosecution has a little bit of a hard time saying what led you to Chad's backyard. But there's a lot of other circumstantial evidence that comes into play. Chad's text messages to Tammy about shooting a raccoon and burying it in the backyard and burning tree limbs. And he was clearly trying to cover up some activity in his backyard. So that led them to be suspicious anyway. The reaction of the cadaver dogs, which alerted in the two places that the cell phone data indicated might be suspicious. FBI going back there and taking a look at it and discovering that the grass growth pattern was very different. Good question. They looked at the grass patterns. They looked at the reactions of the cadaver dogs. They looked at a whole bunch of different things in order to say, let's dig here. So Lee here's asking the question, if the CAS data is not accepted, would that invalidate the search warrant for Chad's home? I don't think so, because the search warrant, as search warrants usually do, list a whole sort of series of these are all of the reasons why we decided we needed to we need a search warrant for his backyard. The text message, all of the other evidence that's sort of racked up, the text back and forth. And I think we're going to see that there was a lot more circumstantial evidence than just the cast. If we were only relying on the cast, you might say maybe a search warrant shouldn't have been awarded on just that scientific evidence. But it would be very unlikely, and it didn't happen here, that a prosecutor would base a warrant solely on one piece of evidence, because just for that reason, because that piece of evidence could be thrown out, the search warrant would still be good. So we talked quite a bit about scientific evidence last week. If you haven't caught that one, go back and get that one. We talked a lot about the cast. We talked a lot about a lot of different other scientific methods, from fingerprinting to ballistics to it's interesting. Just a side note, I've been trying to catch up on the Piketon murders, and ballistics come into play in that one pretty heavily. Do I know any statistics on 2 jury 1 trial if both defendants are found guilty or both not guilty, or a split verdict? I don't know. What would happen is that the judge would, and this is why it gets to be really a lot when you're dealing with 2 juries. What would happen is the judge would bring in, let's say, Lori's jury and sit Lori's jury down. Chad's jury would be in the jury room and would sit Lori's jury down and say, I'm going to read you the jury instructions for your portion of this case. And I'm going to give you the verdict forms for your portion of the case. I'm going to explain all these things, what they mean, and then the judge will read verbatim the jury instructions to the jury. States vary on whether or not those written jury instructions go to the jurors or not. Sometimes the judge records them so that they can play them back. Just depends on the state. Not quite sure what Idaho does, but that jury would get instructed. They would get their juror forms, their verdict forms, and they would be told to go back to their jury room, elect a foreman, and begin their deliberation. Then the judge would bring in Chad's jury and do exactly the same thing, instructing Chad's jury as to Chad's charges and any limiting instructions that may have come up during the trial. So, for instance, if for some reason information came in that Chad's jury heard that they should not have heard, the judge would give them a limiting instruction and say, you were ordered to disregard this information as it applies to Chad. And so you can't consider that when you're doing your deliberation. So the judge would instruct both juries separately, and the juries would go back and deliberate separately, and they would bring back their individual verdicts. So it's really not very different from having two separate trials because you have two specific juries. The juries are not, the only thing the juries are hearing are the testimony and any instructions that come to them as a result of objections. So where it gets tricky is, let's say John Pryor objects to something, and then all the juries have to go out while they discuss how it's going to be, how the judge is going to rule and what the instructions to the juries are going to be, and whether Lori's jury is going to be instructed or Chad's jury is going to be instructed. So, I mean, that's where it gets tricky, is this choreography of trying to make sure that we're not prejudicing either jury by bringing in information that could prejudice the other defendant. So those are good questions, and that all goes back to the issue of whether or not to sever the case because of prejudice. Now, John Pryor's adamant that his client is going to be prejudiced if the case is heard together. We're going to have to wait and see what the judge does with this. The two jury option may be a good option, but it certainly will require a lot more keeping a lot of balls in the air, and Judge Boyce is not that experienced. So a more experienced judge who's done a gazillion jury trials probably would find it much easier to sort of juggle two juries. But I think it could be concerning because he's not super experienced. Hazelnut, is John Pryor doing this case pro bono? We don't know. And I've talked to a lot of people close to the case, and nobody's really willing to give up that information. We do know that at the point where it appears that Chad ran out of money to pay all of the lawyers because they were married and that money was paying for both lawyers. It appears at the point where he ran out of money, Mark Means then was looking to stay on as a in a public defense role and get indigent funds. Jim Archibald was appointed, and Chad signed his house over to John Pryor. So we know at that point, and that was probably a year ago, that he was putting up his house and signing it over, the title of it over to John Pryor in lieu of attorney fees. But like I say, the house didn't have a tremendous amount of value in it. I mean, yes, $100,000 seems like a lot of money, but when you're trying a very complex criminal case, it's not a lot. Death penalty cases, as I've said before, the average death penalty case to get it from indictment to trial is about $4 million, and usually requires a team of 5. And John Pryor's trying to do it all alone. I don't know that that John Pryor is doing this in exchange for publicity. He's a pretty experienced lawyer, and I don't know that he really needed the publicity. I don't really know. I don't know his motives, and I wouldn't rush to suggest that he was out there for the notoriety of trying the high visibility case. I mean, I think most lawyers would tell you that these high visibility cases can be the death of your, it's more likely that they'll be the death of your career. If we look at any of the big high visibility cases like Casey Anthony and Jodi Arias, those cases really were the end of those lawyers' careers. So Jodi Arias's attorney got disbarred. The prosecutor in Jodi Arias's case got disbarred. Jose Baez, who represented Casey Anthony, spent a lot of money defending a lot of bar complaints and malpractice complaints against him, ethics complaints. As far as I know, he's still practicing, but it was very expensive for him. Is Chad's trial moving forward based on Lori's health? We don't know at this point because the judge has not reset either one of the trials. The judge initially vacated the January trial as it applied to Lori because he put a temporary stay in place because of her mental health. And then later ruled on John Pryor's motion for extra time and said, I'm going to vacate Chad's case as well. So, but that case has not been reset. So we don't have an answer to that yet. And the prosecution surely will bring in the whole zombie rating scale thing too. I'm sure they will. I mean, let's face it, their ideas are out there. And I'm sure that they will bring in the whole zombie thing. Question whether it, I think that they will bring in the whole idea of LDS doctrine certainly teaches that people can be, Christian doctrine teaches it as well. People can be possessed by dark spirits. It was something that was part of their mainline religion and wasn't really that far out. Perhaps the zombie reference was a little out there or a little ill-advised, but the concept that people can be inhabited by evil spirits isn't new or unusual in a lot of different faiths, LDS included. And so I think they're going to say this wasn't that much of a departure from mainstream. And, maybe he used some ill-advised phrases, but it wasn't that strange. It was Lori who took it to the to the extreme of saying we have to kill these people in order to free their souls. I suspect that will be where the defense is going to go with it, is to say, yeah, my guy talked about those things. They're not really that far off of mainstream beliefs. The whole dark light rating scale, maybe a little bit out there, but maybe not. I mean, we do see in a lot of faiths people who can divine those things. We do see in the history of the Bible, people who have discernment and can discern when someone is inhabited by a demon and can cast out demons. And so I think the defense will take the position that is not that far out of mainstream kind of theology, and that it was Lori and Alex who took that to its strange ending. Thank you so much, Hazelnut. I love my mods. I'm so appreciative for all of them, and I appreciate that you guys help us out by sending them a little something, because they deserve it. Jenny, I wonder if Emma sleeps in the room where her mother died. I don't really know who's living in the house now. The last time I was in Rexburg, I went by, and the house is looking pretty run down. I don't know. My understanding was that at the time that the children's bodies were found, Emma was living across the street with her husband, and that they, at some point, they moved back into the house for some short period of time. I don't believe Emma is living there now. But I think that they initially they moved into the house. And I think it I think it may have had more to do with helping their dad out with paying the rent until they could figure out what was going to happen. If John Pryor wants the cases severed, wouldn't it make sense that Lori's defense would also want the cases severed? Why aren't they filing motions to sever as well? Good question. We don't know what their defense strategy is. They have been, understandably, pretty tight-lipped about that. So we don't know what their defense strategy is. And it's possible that their theory of the case means that they would be better off having the cases joined so that they can point the finger directly at Chad. I think it's harder to do with the cases severed. Beth, hi Beth. In my opinion, my never to be humble opinion, by the way, is the marriage over? Do you think that is what sent Lori back to being incompetent? Have I heard any rumors? No, I have not heard any rumors, but I can just tell you from my observation. I think Lori is still 100% all in. I think that was evident by her wearing a hair tie in place of a wedding ring to court. I think she is 100% all in. She still believes that she is a goddess, and she and Chad were appointed by God to lead the 144,000. I think she believes that just like the Apostle Paul, when he was in prison, the earthquake is going to happen. The walls of the prison are going to fall down, and she's going to be freed by God. I believe that she still is 100% in on she and Chad are doing this to fulfill their mission. I don't believe Chad's there anymore. I think that his attorney has been able to bring him to a certain reality about what he's facing. And I think what sent Lori back to being incompetent was the motion to sever. And the motion to sever makes very clear that Chad's defense theory is going to be that Lori and Alex did it all and he was just a willing dupe. So I think that's very clear. And I think that when they sat down and went over those motions with her, she freaked out, understandably, because she's still all in. So hopefully that makes sense. Thank you, Louisa. Thanks for joining us. I'm loving doing this. And I'm hopefully going to get a little better with the technology every time we go live. I did have one viewer who does a lot more YouTube work than I do, who pointed out that I should be looking at the camera. The problem is you're up here. So I need to rearrange my camera so we can make eye contact, but I'm working on that. And in the meantime, we're trying to work out the little glitches. I'm super excited that we're going to be, thank you, Brown Eyed Girl. I am super excited that we're going to be on Tuesday. That'll be start next week on Tuesday. We'll be live. I try and keep these lives to an hour. It looks like we're about 5 minutes over, and I don't want to keep anybody from hopping over to Lauren and John's interview with Heather Daybell. So I am going to wrap this up. We'll try and keep Tuesdays to an hour as well. Please let me know if you have suggestions of things to talk about. There are plenty of other cases to talk about, everybody from Letitia Stout to Murdoch to Delphi. So, but if you will email me questions in advance, it'll be helpful because it's a lot to wrap your arms around, and I'd love to be able to do a little bit of work at a time to answer those questions. So I want to thank everybody for joining us tonight. Hopefully we answered some questions about what happened this week in the hearings. We'll see you all on Tuesday. Please join us then. And please thank our moderators for their participation. And if y'all want to bounce over to Hidden True Crime, I think you probably could catch up on that great interview with Heather Daybell. So thanks for y'all for being here tonight and every Friday night. Have a great weekend, and I'll see you on Tuesday.